Have you ever granted someone legal authority to act on your behalf, only to realize later that you need to take back control? It is a common situation, and thankfully, you have clear legal pathways to make sure your wishes are upheld. A power of attorney is primarily cancelled through a formal written revocation document. This document, signed by you, the principal, formally ends the legal authority previously granted to your agent. It is the most direct and legally sound way to ensure that your agent can no longer act on your behalf. Other ways a power of attorney can terminate include your death, the death or incapacity of your agent, or if the document itself specifies an end date or condition. The reason a formal revocation is so important is rooted in the legal principle of agency. Once you grant a power of attorney, institutions like banks or hospitals are legally obligated to recognize your agent's authority. Without a clear and unambiguous termination, these third parties might continue to honor your agent's actions, even if that is no longer your wish. This formal step protects you, your agent, and the institutions involved by removing any doubt about the agent's current authority. To effectively cancel a power of attorney, you should first draft a document specifically titled Revocation of Power of Attorney. This document must clearly state your intention to revoke the previous power of attorney, identifying it by date and the names of the principal and agent. Next, you must sign this revocation document, and in many states, it needs to be notarized. Some states might even requiring witnesses. After signing, it is crucial to deliver a copy of this revocation to your agent. Then, you must also notify any third parties who previously received or relied on the original power of attorney, such as banks, financial advisors, or healthcare providers. If the original power of attorney was recorded with a county recorder's office, for example, for real estate transactions, you should also record the revocation there to update public records. It is particularly important to understand how revocation applies to a durable power of attorney. A durable power of attorney remains effective even if you become incapacitated. Therefore, revoking a durable power of attorney while you are still of sound mind is vital to ensure your continued control over your affairs. If your mental capacity is questionable, the revocation could be challenged, highlighting the importance of acting promptly and clearly. Consulting with a legal professional can ensure your revocation is properly executed according to your state's laws, preventing any future disputes or misunderstandings. Taking these steps to clearly and formally revoke a power of attorney ensures that your financial, legal, and healthcare decisions remain as firmly in your hands or are managed only by those you currently designate. This proactive approach helps to prevent any potential misuse of authority and secures your peace of mind, knowing your affairs are managed exactly as you intend.